Hi everyone, welcome to the session on international arbitration. Today, we're going to look at the extraterritorial control exercised by the Indian judiciary in foreign seated arbitrations.
We'll start by looking at where it all began, which is with the Bhatia International case before the Supreme Court in 2002. Let's first look at the facts of the case. This case involved an ICC arbitration seated in Paris. One of the parties, the respondent, approached the Indian courts under Section 9 asking for interim relief to freeze the business assets of the claimant who was situated in India.
The court struggled with finding the source of its jurisdiction under the Indian Arbitration Act.
Section 9 of the Act, which allowed the Indian courts to award interim relief, was situated in Part 1 of the Indian Arbitration Act. Section 2, Subclause 2 of the Indian Arbitration Act made it very clear that the entire Part 1 of the Act, including Section 9, applied to arbitration situated in India. The claimant raised the plea of maintainability of such an application and contended that Part 1 of the Act, including Section 9, would not apply to arbitrations taking place outside India.
The court solved this problem by coming up with a rather tenuous interpretation of Section 2, Subclause 2.
The Supreme Court looked at Article 1, Subclause 2 of the UNCITRAL Model Law, which was similar to Section 2, Subclause 2 of the Indian Arbitration Act, except in two ways. 1. It expressly allowed courts of one state to grant interim relief under Article 9 to arbitration seated in another state. 2. It contained the word only, which Section 2, Subclause 2 did not. The court pounced on the second difference, that is, the use of the word only in Section 2, Subclause 2, and held that the legislative intent behind Section 2, Subclause 2 was not to limit the application of Part 1 of the Indian Arbitration Act to Indian seated arbitrations only. In other words, the court reasoned that the omission of the word only was intentional. Using this interpretation, it was able to explain away the first difference, that is, the exception created for Article 9 in Article 1.2 of the UNCITRAL Model Law. By generally allowing Part 1 to apply to international arbitrations, there was no need to separately provide for the same with respect to Section 9. The court justified this interpretation by stating that this was the only interpretation that would ensure that a party seeking interim relief in foreign-seated arbitrations would not be rendered remediless if the assets were located in India.
The ramifications of this judgment have been enormous.
Indian courts could now obviously grant interim relief under Section 9 in foreign-seated arbitrations. In fact, Indian courts even started appointing arbitrators in foreign-seated arbitrations under Section 11. In the citation Infowares and Intel cases, while the arbitration agreements did not contain an express choice of seat, they both contained foreign governing laws. The court nonetheless applied Part 1 and Section 11 and appointed arbitrators in these arbitrations. Most controversially, the Indian courts could now vacate or set aside foreign awards under Section 34. In the infamous Venture Global Engineering case, the Indian Supreme Court not only made it clear that Section 34 would apply to a foreign-seated arbitration, they also made it very clear that the Indian judiciary's expansive interpretation of the public policy ground to set aside an arbitral award under Section 34 applied to foreign-seated arbitrations. We won't get into a huge amount of detail here. At this stage, it is enough if you know that the Indian courts in ONGC versus Saw Pipes in 2003 held that they can set aside arbitral awards under Section 34 for patent illegality, that is, for basically being illegal under Indian law. We will discuss ONGC in more detail in Unit 7. Throughout these decisions, from 2002 until around 2012, the courts allow one escape route for parties seeking to avoid the application of Part 1. Courts said that the parties can expressly or impliedly agree to exclude the application of Part 1 in foreign-seated arbitrations.
The courts were pretty whimsical in their approach to interpreting what an implied waiver was.
I mean, sometimes choosing a foreign seat was enough to amount to an implied waiver. Other times it was choosing a foreign law to govern the arbitration agreement, but they usually always respected express exclusions. We've discussed these in Unit 2. That's why lawyers drafting international arbitration agreements with an Indian party, good lawyers at least, would always include the express exclusion language in their arbitration agreements. The position has totally changed since 2012 with the Bharat Aluminum or BALCO decision given on 6 September 2012 by a 5-judge bench of the Supreme Court. The Supreme Court in BALCO rightly concluded that the omission of the word only in Section 2 Subclause 2 of the 1996 Act cannot be interpreted in a manner to show that the Indian legislature had deviated from Article 1.2 of the Model Law. Section 2 Subclause 2's words were intended to limit the application of Part 1 of the 1996 Act to arbitration seated in India only. The case obviously comes as a huge relief to the international arbitration community. It removes a lot of the uncertainty associated with implied and express exclusions and realigns the Indian law with the model law. That said, there are a few areas of concern. 1. The ruling is prospective, that is, it only applies to arbitration agreements entered into after 6 September 2012. 2. The court did not solve the lacunae in the Indian Arbitration Act with respect to interim relief. In fact, the court made it clear that having held that Part 1 does not apply to arbitration seated outside India, it was only logical that Section 9 could not be used to provide relief in such arbitrations. The 2010 consultation paper's recommendations in this regard are useful. Unfortunately, there has not been too much movement to amend the Indian Arbitration Act in line with the consultation paper's recommendations since it was published. That's it for this session as well, folks. Thanks for watching.